Okay, Attorney Sewell.
Good morning, Your Honours. I'm Bernadette Dunn-Sewell. I represent the City of Waltham and William Forte. This case is about the extent to which a municipality can determine where solar installations may be placed within the confines of each municipality. Section 3 of Chapter 40A states that no zoning ordinance or bylaw shall prohibit or unreasonably regulate the installation of solar energy systems that facilitate the collection of solar energy except where necessary to protect the public health, safety, or welfare.
So tell me this, why is an access road not a structure that facilitates the collection of solar energy?
It's not defined. If you look, in fact, at the brief that was filed by the appellees, they try to shoehorn an access road into a facility that is permitted for generating solar power.
So let me ask the question again. Why is an access road not a structure that facilitates the collection of solar energy? After all, the access road is helpful in getting to the Lexington site in order to construct what I think you concede is a solar energy system, which is for the collection of solar energy. So why isn't the access road itself a structure that's helpful?
Because it's not a structure.
And so when you say an access road is not a structure, what definition of structure are you looking to?
Your Honor, I started to say that the appellees tried to shoehorn their description
But I don't really
of what
care
was
what the
allowed.
appellees
But
say.
what-
I
but
would
what
like
they-
to know what you say is inconsistent with the word structure and an access road.
Because it talks about that facilitate the collection of solar energy. It's helpful, but it's not necessary. It's certainly not necessary in the place where the appellees are trying to locate
So
this
where
particular
in
one.
paragraph 9 are you finding the word necessary?
Well, it says that facilitate the collection of solar energy.
Yeah, so what facilitate means helpful, right?
Helpful, yes.
Okay. So isn't it helpful to get access to the Lexington site in order to build a solar energy plant?
Yes,
Okay.
but this particular route is not the only access.
Yeah, but
They could
again,
actually
I
go
don't-
through Lexington
that's
or another
not-
part of
that's not-
Waltham.
Well, I guess, yeah, explain to me why you think there needs to be an only route in order for it to be a structure that facilitates the collection of solar
I'm
energy.
sorry, there needs to be,
You're saying that the Waltham site needs to be the only route in order for it to facilitate the collection of solar energy in it?
no, Your
Okay, so
Honor,
what is it that you're saying?
this is not the only route that they actually have in order to access the Lexington site. There is access by right through Lexington and also parts of Waltham where the two of them come together. And it's conservation land, but they actually, given the fact that it's a solar installation, they have an as-of-right access through that. They have chosen not to take that route and instead have chosen to take the route of going through a residential area in Waltham. And the only thing that they could point to was the fact that there will be a small retaining wall on this access road. And that, they say, links it, or they don't out and out say it because it's a difficult thing to do. But otherwise, that access road isn't connected to solar energy systems and the ability for those systems to generate solar power.
Can you address, the land court judge says, when you cut off 98% of the land in the town.
And I'm glad we've reached that.
Yeah, okay.
It is simply untrue that Waltham doesn't allow solar installations on 98%. It simply is not true. Waltham has,
So that's a factual error by the land court
it
judge?
absolutely is a
So-
factual error.
And how can we, go ahead.
And in fact, the city, in its motion for summary judgment, provided the court with all of the information, but the court didn't even mention it, and relied only on that 2% that the court investigated itself. The 2% is the industrial zones in Waltham. And what Waltham does is it says, if you're going to have a solar installation that is greater than 1 megawatt, which is the equivalent of a power plant, then we are going to restrict you to the industrial areas. But Waltham allows in every other area in Waltham
Well, hold on,
accessory use.
are they allowing those little solar panels on the house? Is that what you're saying? Is that why they're not?
Even more than that. Even more than that.
Why don't you be specific? Because this is, the land
So-
court judge says, okay, I've looked at, they want to build this kind of plant, and only 2% is available. Tell us why that's wrong, or at least divvy up the type of solar that's possible here for us.
That's the problem with the lower court decision, is that there's no differentiation between the size of the installation that Tracer Lane is looking for versus any other type of installation. Yes, the size of the installation that Tracer Lane wants to put in Lexington and access through Waltham would only be in the industrial areas. But that doesn't mean that the rest of Waltham doesn't allow solar installations. If you look at, in the appendix that was submitted, if you look at pages 189 to 261, every one of those pages has lists of every solar installation that Waltham has allowed.
But are those just on?
More than 1,000 at
But I mean,
least.
are we talking about the little ones on houses? Is that what we're talking about?
We're
Or are we
talking about everything. We're talking about public buildings. And public buildings are generally large buildings, schools, commercial buildings, parking garages that have above ground structures that allow solar installations on those. You cannot go to any zone, any area of Waltham without seeing solar installations. They are just not as big as the installation that Tracer Lane is plans on installing in Lexington and through the residential area in Waltham that it wants to go. Waltham does not run afoul of paragraph 9. It doesn't prohibit any solar installations. It reasonably regulates solar installations. The large ones can go in the industrial areas. Anything smaller than those larger ones, if they're an accessory use, meaning it's not their principal reason for being at a particular location, but accessory to the principal use, then they are permitted everywhere.
Is that how we assess Section 3 cases on a sort of citywide basis?
I'm sorry, could you say that again?
Can you give me an example of a Section 3 case where we've assessed the reasonableness of a regulation or a bylaw ordinance on a citywide basis? That is, take childcare. I'm the city of Waltham, and I have zoned childcare to the industrial zones, and you can have at it all childcare in the industrial zones. The residential zones, no. Is that a reasonable regulation under Section 3? Is that
No,
how we
because-
analyze it?
Okay, because those sections are different from paragraph 9, or those paragraphs are different from paragraph 9. Those, the paragraphs that come before paragraph 9 deal with childcare centers, schools, agricultural use, and so on. They are all very much part of the community. We want childcare centers, we want schools, we want farmland within communities. Section 9, and we don't allow anything other than reasonable regulation, and you can't prohibit them. But with solar, there's more leeway for a municipality. The language is different from the language of all of the other paragraphs. And it's that additional regulation that is granted to municipalities that we definitely want to preserve, and which frankly
Can
the
I
court
stop
needs to
you?
clarify.
Can I stop you? Let's take agricultural, paragraph 1. How is that language different? It says, no ordinance or bylaw shall prohibit or unreasonably regulate.
Well, that one is similar. That one is similar.
Okay.
Okay.
And so let's use that one since it is similar. Is that done on a parcel by parcel basis, or is that done on a citywide basis?
No,
That is,
well,
I'm
that-
the city of Waltham and I want to say, I'm going to be consistent with paragraph 1, but you can't have, I don't know, a horse barn unless it's in the industrial zone. Is that how we analyze it?
Well, there are cases that have looked at the agricultural paragraph based on the city or town itself. If you wanted to put a horse barn off Moody Street in Waltham, which is part of a residential zone, you might have a problem. It's a very built-up area. Where exactly would you put the horse barn? But if you're talking about Western Massachusetts or Central Massachusetts, where you have residential zones and plenty of space for a horse barn, then prohibiting the horse barn in Central Massachusetts might be unreasonable. It wouldn't be unreasonable in Waltham, because Waltham is a much more built-up area.
Can you give me any legal authority where we've analyze the Section 3 cases on this citywide basis as opposed to parcel by parcel?
Are there any cases that do so?
Yeah.
Well,
As you were saying, Waltham's got a reasonable plan, right? Overall, we don't prohibit solar, and we allow the plants in industrial zones. That's totally reasonable, and I'm not disagreeing with you. But I'm wondering if that's how we analyze Section 3 cases. If you know of any examples in your extensive research that you found where we analyze it on a citywide basis.
I don't have a case off the top of my head, Your Honor, but the line of cases seem to look at both citywide and parcel by parcel.
What is that line of cases? Can you give me just one?
Well, for example, the cases that have come through the land court that have now resulted in our coming up here, there are 2 cases, Dussault and Briggs.
Right, but those cases are on review. I'm trying to figure out any other Section 3 cases where we do this that way. And it's okay if you I haven't found any, but I wanted to ask, give you the opportunity to tell me you have.
I guess what I'd rather ask, because I probably have the answer to that, is where we're going with this, why that is an issue, when what we should be looking at here is whether what Waltham is trying to do is unreasonable under the circumstances.
But from your argument, they're tied together. Your argument sort of is, this is unreasonable. This is a cul-de-sac, and it's a quiet road, and now you're going to come through for how many months, 8 months, with all these big trucks, and it's not even for Waltham. It's for Lexington. And by the way, we have plenty of solar. Don't just look at the 2% commercial. We have plenty of solar here. So this is unreasonable. So what would help that argument a lot would be any suggestion that in Section 3 cases, you look at the circumstances of reasonableness by municipality.
Okay, you have to look at what the consequences of a decision that would uphold the land court decision in this case might mean for municipalities in Massachusetts. If the court upholds the land court and says Waltham can't stop Tracer Lane from using this residential lot as a through road, then what you're saying is that it's basically a free-for-all for solar installations. I'm not saying that there shouldn't be solar installations in every single town. Obviously, we're all sensitive to the need for solar installations, but there has to be some way for, or there has to be authority in the municipality to say, when it's going to be as big as the one that you're looking at, it has to be in this area. Otherwise, you can have solar installations all over the city, but something that is that big has to be in a certain area. And let me sort of follow through on what the logical consequences
Can I
of
ask,
a
but
decision.
I want to make sure I understand that. Are you saying any one of these sort of commercial enterprises? I understand people put solar panels on their house, and you're saying some of the city buildings may have on top of their garage, but if someone wants, they're in the commercial solar panel business, can they have a smaller commercial solar panel? Is it just this number has to be in 2%? But if they cut it down in half or 3/4, does that open up any more than 2%? Or is any commercial, because I just want to pin you down, any commercial solar panel restricted to 2%?
Anything of that size,
Well, that's
one
not the-
one-
that's
one
the-
megawatt plus.
I want to do the commercial.
if it is
Anything that's not putting it on your house. If someone wants to, they're in the solar panel business and it's not putting on your house, are they limited to 2% of Waltham? Is the land court judge right?
No, there are much bigger installations that are not just what you would put on your house. Does the Waltham ordinance
Example.
specifically authorize that? It does not, because it allows for accessory use. This is a principal
What is
use.
the definition of accessory use?
Accessory use is use of land, building, or part of a building that is customarily incidental and subordinate to the principal use of the premises.
Then it's clearly not commercial. Then you have restricted it to 2%.
I'm sorry?
Then you have restricted it to 2%, because in order for it to be anything else, it has to be meet this definition of accessory use, which is subordinate to the primary use, right?
Your Honor, we have to look at more than just what is happening in this case.
That's our job.
Okay, well, Waltham does not have a comprehensive solar energy ordinance. We can't get past that. But we do allow solar use, as I said. But there are lots of communities that do have those sorts of regulations in place. And if the land court decision is upheld, and it's basically solar installations under paragraph 9 can go anywhere.
They're saying the opposite. It's a narrow decision. It says, look, you guys, by limiting it to 2% of your area, are unreasonable. That's all this decision says. They're not saying, the land court's not saying, you can stick solar panels wherever you want. It's just saying Waltham's made it impossible for this to happen because it's restricted to 2%. I thought the land court decision's narrow.
No, Your Honor, because the land court didn't even consider the fact that Waltham does allow solar use.
The land court may have made a factual error. That I don't, but I can't judge that yet. But the land court is not issuing a broad, what the land court, at least my sense of the holding was, it's unreasonable to restrict solar panels to 2% of your population, 2% of your geographic area.
But it's not just solar to 2%. It's solar of that size. That's what can only take place in the industrial area.
It's actually solar where it's its primary use. The only solar allowed in Waltham is accessory use, except for in 2% of the population, right? That's, if the land court judge was more precise, that's probably what he would have said, right?
Yes, and Your Honor, if someone wanted to build, half the size of an array in a commercial district and Waltham said no, I think there'd be a pretty good chance that would be considered unreasonable. The facts that we have in this case are not unreasonable, because what they want to do is to use a residential zone for commercial purposes, and that is the fact that they should not be able to do that is a well-established principle.
Well, can they use any other zone? Do you have zones besides industrial and residential in Waltham?
Commercial. We only have 4 single-family resident zones. And this
So if they
is,
tried to build in a commercial zone, it would have been permitted or no?
that would probably be a different matter. Would it be permitted as the ordinance stands now? Possibly not. Would there be a successful challenge to it? I believe so, because
Okay,
that
I'm gonna-
possibly could be unreasonable.
Thank you. Your time's up, and I'm going to move over to
Thank you.
the other side. Thanks so much. Okay, we have Attorney Fixler.
May it please the court. David Fixler, Tracer Lane 2 Realty LLC. I want to focus immediately on the dominant two questions that were being asked to the appellant. First of all, the test isn't what walking around Waltham, what installations may be there. The test is what does the Waltham zoning code permit and prohibit. And the Waltham zoning code, they argue, oh, you can be in Waltham. Look, we allow it as an accessory use, we allow it as a use variance. But unfortunately for them, in section 3.211, which is their accessory use provision, it only allows accessory uses that don't include any activity that's prohibited under the Waltham zoning code. So since solar, arguably under their argument, our argument is it doesn't regulate solar at all. Their table of uses doesn't regulate solar, and there's a clause in their zoning code that says unless a use is expressly permitted, it's prohibited. But putting that aside for a second, even if you take their argument, it's only allowed arguably as a power station, and that's only an industrial zone. So this accessory use is actually illegal because solar can only be used in the industrial zone. Two, they say in their brief that we allow for use variances, but under MGLC 48 Section 10, you can only have a use variance if it's expressly stated in the particular municipality zoning code, and it's not. And third, what's really going on with these, with the rooftop and the other solar that the appellant is talking about, that's just case by case ad hoc zoning regulation, which of course is illegal because there is no uniformity of standards. Second, to the question of are there any cases where they do it by municipality, the answer is no. There are no appellate and SJC cases. Every single case that has analyzed Section 3 has said that it's an allowed use, it's as of right in all zoning districts, and the analysis is then done on a parcel by parcel, site-specific basis.
Can I ask a question about that? So does that mean if Waltham had 50% of its area zoned for solar, would that make a difference for you? Would that make it a better case for Waltham or no?
No, it would not. It's an as-of-right use in all zoning districts. It doesn't mean it's an as-of-right use on every single parcel in a particular zoning district. And there is no stopping a municipality under paragraph 9 of the statute from reasonably regulating. In fact, some municipalities do that. They have narrowly tailored, non-discretionary regulations that have a direct nexus to the use. They take into account the site-specific, the topography, the surrounding built environment, and that's how they regulate it. But it's as of right in every zoning district, and the reason is because it's been placed in Section 3 by the legislature. The legislature, in enacting the Solar Act in 1985, was prescient. Not only did the legislature say that it's important for the Commonwealth to invest in and promote renewable energy such as solar, they also foresaw that siting solar energy systems could prove to be challenging at the local level, and therefore stated that the use of the land for such purpose is going to be protected and exempt from zoning regulation, which of course is the title of Section 3.
Taking into account that we're dealing with the Dover Amendment, if you have a circumstance like this where there's a residential road and it's going to be traffic for 8 months, does the circumstances here, whether it was raised or not raised, include concerns about protecting the public health, safety, or welfare?
So if in fact well, first of all, there is no regulation, and there's no zoning regulation in Waltham to do that as applied test because they just facially say it's barred. If the question is, if they had a zoning regulations, a narrowly tailored one, such as the one that I just articulated, is that the question, Your Honor?
And in that circumstance, could the fact that it's on a cul-de-sac in a residential area, there's going to be trucks for 8 months and then periodically with maintenance, could that be considered under the actual language of Section 3?
Well, it's the land, that access road is a protected use. So then the analysis would be on a site-specific basis. Does that use, would that use impact health, safety, and welfare? But it would have to be exactly looking at what you're doing there. And there actually is a land court case that's right on point on this, the Northbridge-McQuaid case, which talks about an access road. And you're looking at what is the use on that. And the use here, there are minimal impacts. It's the solar facility is a passive facility. So once the construction is finished, there's not going to be any real use, and the construction itself isn't going to take that long.
I'm confused. They couldn't pass a regulation that said you can't have solar facilities in residential areas, but they can have them in commercial and industrial in a place that's got a significant percentage of space devoted to commercial industrial? I mean, it's a big deal to put one of these things in a residential neighborhood.
So I would answer that question two ways, Your Honor. First, the market is going to cull inappropriate parcels. With the real battle,
I'm not buying that one, but go
okay,
ahead.
then the next answer then is that the answer is no, because it's a protected use. The way to go about the problem that
But
you're
you have to do it
articulating.
on a totally individual, the cases, because again, this is a very experienced, knowledgeable land court judge, and in a big fight that they're having on the land court. There really isn't the ability to take into account the overall percentages. I'm surprised at that, but we'll look for the cases. But
The reason for that, Your Honor, is that it's an exempt use under Section 3.
But
So
what
therefore,
what does reasonable regulation mean then? 'Cause
you have to take it on a case-by-case, parcel-by-parcel basis.
Give
So-
us examples, please, of what would be under the Dover Amendment, this reasonable regulation in this case.
Well, I think you could
And
look.
I know you're arguing it was per se in this case, but help us flesh this out. What is a reasonable regulation of a solar farm?
There could be reasonable dimensional regulations, there could be setbacks, there could be screening, but the regulation has to be narrowly tailored such that it can trigger a site-specific review instead of a categorical upfront banning the use entirely.
Would
before
it
you-
include putting it at the tail end of a cul-de-sac to serve another town?
At that point, you could, but then you could always challenge that on an as-applied basis. But again, if you're looking at the use of the access road, first of all, it is part of the solar system, and so you have to then look exactly what is the real use of the land that's going to be impacted for that. But again,
Is there a benefit to Waltham from this project?
well, yes.
Apart from the esoteric environmental?
But that is the benefit, and that's where the legislature had such.
The electricity is owned by Lexington, correct?
But we have an existential challenge in this Commonwealth, and
I know, I've read all that stuff, but let me ask you something. Is there a benefit to Waltham from this apart from that?
Yes, I'm sorry, Your Honor, but the benefit is that the whole Commonwealth is able to combat that, and this is the reason why the legislature put it as a
All
protected
right,
use.
but maybe I shouldn't have interrupted you, answered Justice Catholick's question, but even under the Dover Amendment provisions, there still is reasonable regulation. Applied to this case, what is reasonable regulation?
A reasonable regulation, well, the record already reflects what our client is willing to do for protocols to mitigate any kind of impacts. There's going to be about 12, the land court judge found that the amount of trucks that are going down the road is minimal. We're going to be sweeping every day, and that you can regulate the use of the road there, but you can't prohibit. There are reasonable regulations that could be put in place, but Waltham doesn't have any zoning regulations that could do that because they categorically ban the use. And I just want to go back to my sort of global point, which is that's the reason
But
why it's in.
Again, it says, no zoning ordinance or bylaw shall prohibit or unreasonably regulate. You're just saying the only thing they can do is they have to permit it, but they can mitigate it. They can require mitigation measures. You're basically saying, in your interpretation, they can build it anywhere, no matter, they have a right to build it anywhere as long as they mitigate the construction impacts.
Build what anywhere?
Your solar system, as you refer to it.
Well, no. The solar system, again, like many municipalities do, there can be a narrowly tailored regulation that talks about dimensional, that culls inappropriate parcels from consideration. That is what's happening in municipalities that have adopted a narrowly tailored solar bylaw. They look at Lexington, for example. Lexington, solar is as of right in every district, subject to site plan review, and then they have different categories of
That's one
solar.
reasonable regulation, but could another one be, hey, we're a town that has 25% residential and 75% commercial and industrial. We don't want you to put your solar panels in our people's neighborhoods, but you can build it anywhere in our commercial or industrial area. That's unreasonable?
Yes, Your Honor, because
Tell me which case says that, because it would be useful for me to know the case that says that's unreasonable.
Every Dover Amendment case says that it's an as-of-right use in every district. Again, that doesn't mean it's an as-of-right use on every parcel, which you can then reasonably regulate on a parcel-by-parcel, site-specific basis.
And cases make, that was brilliantly articulated. Does a case say that you cannot do this by the way we normally do? In Dover cases, you cannot divide between residential and commercial. You can only do it parcel by parcel. It seems like it's a very nice articulation of the law. If you have the case, I would love to read that.
Okay, well, there are no appellate cases that specifically say that for solar, but the land court cases, that every land court case that has gotten this issue, that's been confronted with this issue, because in Dussault case and the Briggs case that the appellant mentioned, the issue actually wasn't contested, but in the Northbridge case, the PLH versus East Longmeadow case, our case, every land court case that has dealt with this issue where the issue is, can you categorically upfront just exclude certain zoning districts from consideration? The answer has been no, because that violates the Dover Amendment. Instead, the analysis is on a site-by-site, parcel-by-parcel basis. And the reason is, as the land court judge has said in these cases, is that the Section 3 requires municipalities to stand down and help the Commonwealth assist in this protected use. The problem is the municipalities are not standing down. If you look at the ASD case, which is cited in the briefs, there's a case in an area where there's lots of land, and they have a solar bylaw that's actually narrowly tailored to answer the questions. It actually has it checks off every bell and whistle that you would need. And then what happened was the planning board said, nah, we don't like this. And so we're going to try and graft on a special permit requirement in addition. And the land court said, no, you can't do that. This is the problem, and that's why it's in Section 3. It's similar to the other uses in the sense that it is a use that can be seen as unwelcome at a local level and be discriminated against solely because of the use itself, not on its compatibility with the land. And the way to regulate it so it's compatible with the particular neighborhoods and such is to have regulations that do exactly that, but that it doesn't prohibit it categorically up front.
But, we're trying to discern a limiting principle here, because I completely agree with you that the access road is a building or structure that facilitates the collection of solar energy. That seems pretty clear. So that means that the area in which you could have an impact is considerable in a municipality. So whether it's commercial or residential, there has to be some, and I appreciate it's the Dover Amendment, and you're right, they were prescient in 1985 to realize there'd be resistance, but there still has to be a limiting principle and an opportunity to be able to demonstrate that there shouldn't be a placement in this particular area.
And Your Honor, the way to do that is through a regulation that takes into account the specific surrounding built neighborhood and topography and things like that. That's what these solar bylaws do if they're done properly. So it's not automatically prohibited in any zoning district. However, within the zoning district, there are site-specific, the regulations allow a site-specific test.
So if Waltham were ahead of this, and just as Kath was talking about percentages, and it's only 2% here, they were ahead of this, and they had limitations, and they had 25% commercial availability for solar, it might be a different case?
No, it would not be a different case in the sense of, if you're asking, can there be a categorical, does it matter whether it's 2%, 50%, 60%? The answer to that is no. The answer to the effect of your question is, if they had a regulation that was like some of the other, like Lexington's or some of the other, that actually took into account the site-specific areas and the topography and things like that, and did it on a sliding scale and had different categories, then the answer, it could be that your use might not make it. However, then you would still have the ability to say, on an as-applied basis, I still have the right to challenge that. But what we have here,
in this case, without the regulation that you suggest they should have had, right? We have to go by, and I get your argument that they're saying it categorically, so that's why, in your opinion, they lose. But if it wasn't that way, and say it was an access road and it was cutting through a preschool, right, and something absurd like that, which obviously is in this case, they could say this is the wrong place for an access road to get to a solar farm, correct?
So what happened here actually is that they prohibited the road based on a long-held zoning principle.
No, the commercial.
Yeah, that
right.
that you judge the parcel where the access is, because the principle is land to which an access leads is an extension of the principal use of the land where the access is, and if that use is barred where the access road is constructed, therefore it's barred here. That's actually how this came up. They said,
So it doesn't matter in this case because it was categorical. So this isn't a case for a remand for them to come up with reasons. They made their bed. They said it was categorical.
That is correct, Your Honor. There is no ability to remand because there is no zoning regulation that's applicable to this because they categorically excluded it.
What if they passed a zoning regulation next week? Too late?
It's too late for our case, yes.
Okay, because, they wouldn't necessarily know that this was coming, right?
Well, I mean, their neighboring town, Lexington, did. This statute has been around. There are municipalities that are doing this and that are making well-tailored laws. Some, unfortunately, are barring the use in residential areas that have 50-acre parcels, and they're just barring it.
That's for another day when you bring the next case as to the reasonableness, right?
Well, no, I don't. For our case, our judge did not actually categorically answer the amicus question that you posed, because he said, under no circumstances can you categorically exclude 98% of the land from even consideration of solar facilities. But the answer to the amicus question is no. You have to be able to. It's a protected use. It's an allowed as of right use in every zoning district. That doesn't mean it's allowed as of right use on every parcel. And the AG's brief puts out some regulations at the end. So their thoughts on what regulations could be. There are some of the other amicus briefs too. And it can be regulated. There's not going to be solar here, solar there. It's going to be where it should be. The problem is it's not being allowed to go where it should be, and the Commonwealth wants to promote solar, and it's doing everything it can under the SMART program, but it can't do everything when it comes to siting. The only thing it can do on siting is to tell the municipalities through the Dover Amendment, this is a protected use. You have to stand back, and it can only be regulated under certain circumstances on a site-by-site, parcel-by-parcel basis.
Okay. Thank you very much.